So we offer leading technology and privacy law expertise, advising our clients at the intersection between technology, law and regulation. Our team based in San Francisco enables us to provide real-time and in-time zone support to our clients, which is of huge benefit and comfort to clients in the context of, in particular, crisis management such as data breaches. In addition, we have the wealth of experience in assisting our clients in scaling their businesses into the European market and assisting them with navigating the entry into the market, the expansion of their business, and the regulation and the requirements that come with doing business in and through Europe. So first, the AI Act is the world's first legislative regulation of artificial intelligence, and the text of the AI Act was finalized in late 2023, with us expecting to see the text finalized and published officially in early 2024. Now, at a high level, the EU's AI Act will regulate certain types of artificial intelligence, including general purpose AIs, as well as high-risk AI systems. Now, in terms of the impact of the AI Act, it will mean that certain types of AI will be subject to conformity assessments, which means that prior to launch on the market, they will be subject to similar sorts of assessments and market criteria that we would see in other regulated spaces like the biotech or medtech space. So the next piece of legislation is the Digital Services Act, or the DSA. The DSA, which is in full force as of February 2024, regulates online content and applies to online intermediaries, in particular online platforms, marketplaces and search engines. Now, for some very large online platforms and very large online search engines, these obligations have already been in place for some time. However, for the vast majority of online intermediaries, these obligations will be new and will mean that there are considerations in respect of the online content on their platforms. In particular, the DSA introduces obligations around transparency, particularly in relation to advertising and recommender systems, and also in relation to content notice and takedown. In addition, there is also dispute resolution mechanisms and general obligations in relation to content that appear on online intermediary platforms. So finally, the third piece of legislation is the Screening of Third Country Transactions Act 2023. This is expected to come into place in Ireland in Q2 of 2024. And essentially, this is one of the most important pieces of legislation in Irish M&A in recent years. In essence, it requires mandatory reporting for certain transactions, in particular relating to critical infrastructure and in relation to critical technologies and dual-use items, which could include AI, biotech and nanotech. So Ireland is an English-speaking common law jurisdiction with access to the EU market. In addition, we understand that US clients prefer and appreciate the clarity and certainty of doing business in or through Ireland, particularly for a prominent location for strategic operations and international headquarters. As a global tech hub with 9 of the top 10 US tech companies choosing Ireland as their strategic presence, we also have and benefit from a wealth of talent locally, particularly in areas including tech, pharma and life sciences.